child was punched and that he was choked, that he was beat with a PVC plastic pipe.
He shot repeatedly, aiming at his head that he would execute.
Why are you at this multiple times?
In May 2024, Julius Cornegay confronted 36-year-old Quan Lillard outside Cairo's Place strip club in Albany, New York. Surveillance footage captured Cornegay stepping into a dispute, drawing a weapon, and firing.
As the victim crawled across the ground, he shot repeatedly, aiming at his head, ensuring that he would execute Kwan Lillard.
After the shooting, Cornegay fled to Florida, but was later tracked through cell phone data and arrested. Throughout the investigation, Cornegay maintained that he acted in self-defense, claiming Lillard had displayed a firearm, though prosecutors firmly rejected this version of events. In March 2025, following a brief trial, a jury quickly convicted Cornegay of second-degree murder, along with weapons and drug charges. During the sentencing, Cornegay apologized to the family.
My life was in danger, and I take full responsibility of my actions.
But this apology was followed by Lillard's mother's emotional statement.
Why are you at this multiple times? You moved everybody out of the way to get what you wanted to do.
Lillard's mother was devastated by the loss.
I agree with Mr. Carty that you should get consecutive time on this murder, but the law doesn't allow me to.
We'll have an opportunity to talk about that on appeal, but not today.
That 25 years do not rock with me. My son is never gonna be here.
Judge Andra Ackerman dismissed Cornegay's self-defense claim, highlighting the excessive violence used in the shooting. Cornegay was sentenced to 25 years to life, with additional concurrent sentences for the other charges.
No hot words to describe that stuff, man.
Yeah, you just go through every day like another day, but he's gonna be on my mind every day. His dream was always to drive school buses. So just to be here and trying to stay supportive of him, and while he's gone, it just breaks my heart sometimes, most of the time.
In February 2024, Daniel Arwood shot and killed his former boss, Aaron Russell, at a Knoxville auto parts store that also served as a school bus parking lot. Surveillance footage captured the entire encounter, showing Arwood, who had been recently fired, confronting Russell and him. During the trial, Arwood claimed that Russell made a comment which triggered him, though he couldn't recall the details, and said he blacked out during the incident. Prosecutors argued that the killing was premeditated, pointing to the loaded weapon Arwood brought with him as evidence of intent. After several hours of deliberation, the jury found Arwood guilty on all charges, including first-degree murder. During sentencing, Russell's family delivered emotional statements, with his brother expressing both heartbreak and relief that justice had been served. Arwood offered no explanation or apology, simply stating he had no words.
No hot words to describe that stuff, man.
The court sentenced Arwood to life in prison, with additional time for weapons charges. He also faces sentencing for lesser charges of evading arrest and driving on a suspended license, with a hearing scheduled for July. In 2017, Gina Emanuel, a registered nurse in Miami-Dade County, adopted 3 sisters. Over time, she subjected the girls to severe abuse, which included confinement, starvation, and physical mistreatment. In November 2018, Samaya developed a disease but was denied medical care. Her condition worsened, and she eventually died from an untreated condition, worsened by ongoing abuse. Authorities launched an investigation, leading to Emanuel's arrest in 2019. Her surviving daughters later testified in court about the ongoing mistreatment they endured while living under Emanuel's care. In April 2025, Gina Emanuel was found guilty of first-degree murder in Samaya's death and convicted on additional charges of aggravated child abuse for the harm inflicted on her surviving daughters.
I wish you well in hell.
I meant what I said.
During sentencing, family members, including the eldest daughter Ayana, confronted Emanuel in court, expressing both their pain and their resilience.
Called yourself a tough cookie. I am too a tough cookie. Tougher than you could think.
She knew what she did. She's guilty and she knew what she did.
Despite the trauma, Ayana shared her hope for a brighter future as she prepared for graduation and college.
I forgive you for what you did. However, I can't forget
I wish I can inflict the pain that you did to my grandkids every day. I wish I could beat you within an inch of your life every day. It really hurt. And I wish that I could have been there a lot sooner. I took it as an insult, and that makes me more angrier than anything, to whereas, I wish I could, put my hands around her throat.
Samaya's grandfather expressed his anger toward Emmanuel.
Life in prison for the first-degree murder. The sentence is the only lawful and just sentence in this case.
The judge sentenced Emmanuel to life in prison for murder, along with additional concurrent sentences for child abuse. Although Emmanuel remained silent during sentencing, her defense signaled plans to appeal. In February 2022, 60-year-old Thomas Arnold was walking home along the Atlanta Beltline after spending an evening with friends when he was approached by Demetrius Ross and Brandon Williams. Prosecutors stated that the confrontation was an attempted robbery, during which Williams fired the shot that killed Arnold. The investigation, supported by surveillance footage and witness statements, led to the arrests of Ross and Williams, who both faced multiple charges, including malice murder and armed robbery. The trial began in April 2025 and lasted 4 days.
We, the jury, found the defendant guilty.
After only a few hours of deliberation, the jury found both men guilty on all counts.
Your repugnant and depraved conduct has earned you the certainty that each of you will perish in prison.
During sentencing, the judge condemned their actions as cruel and calculated.
I don't think Jerry will ever get over the loss of her brother in such a tragic way, but, maybe she'll get a little closure.
While Arnold's family expressed some relief that justice had been served, they also shared the ongoing pain of losing him.
My son is a humble person of love. He's a humble person that wouldn't hurt a fly, never hurt anybody in his life.
We'll do this until we can't do it anymore because we know that these boys are innocent.
Meanwhile, both defendants' families maintained their innocence and announced plans to appeal the convictions. Both Ross and Williams were sentenced to life in prison without parole. In September 2020, Connor Crowe shot and killed his mother, Melissa Rowland, and his sister, Madison, inside their home in Weirton, West Virginia. After the murders, he attempted to mislead authorities by claiming an intruder was responsible, but physical evidence, like shot residue on his hands and a lack of forced entry, quickly unraveled his story. Investigators discovered that Crowe had carefully planned the act and even prepared a false alibi. The brutality and premeditated nature of the crime shocked the community, especially given the young age of the offender. In November 2022, Crowe pleaded guilty to 2 counts of second-degree murder, opting to be tried in adult court. During sentencing, Judge Jason Cuomo emphasized the calculated nature of the killings and noted Crowe's lack of remorse.
You're asking this court for something less than the maximum so that you can make something of yourself. That's what your attorneys have asked, that's what you have said in the file. Your sister would have graduated high school, I think about a week or 2 ago. She'll never get that opportunity. She'll never get to go to college. She'll never get to walk down the aisle with her father and get married or have kids of her own. You took that from her. You gave her no opportunity to make something of herself. But you're asking me to do that to you.
We can't give these 2 young ladies their lives back. We can't give the grandparents their granddaughter back or their daughter. But justice was served the best way it could have been.
On May 30th, 2023, Crowe was sentenced to 80 years in prison, 2 consecutive 40-year terms, the maximum allowed by law. Crowe will remain in a juvenile facility until he turns 18, at which point a hearing will determine his transfer to an adult prison. Parole eligibility begins after 15 years. In September 2018, Sharice Stinson reported her son, Jordan Beliveau, missing in Largo, Florida, claiming he had been abducted by a man named Antoine. an Amber Alert was issued and a large-scale search followed. However, inconsistencies in her story led investigators to question her claims. Days later, Jordan's body was found in a wooded area. Stinson eventually admitted to striking Jordan during a moment of anger. She did not seek help and instead left him alone, where he died from severe injury. During a routine pretrial hearing, Stinson appeared in court on charges of first-degree murder and filing a false police report.
Ma'am, you Cherie Stinson?
Yes, sir.
Good morning. You hear a pretrial, a charge of murder in the first degree and false report to a law enforcement officer. In a case like this, we tend to give it a little more time so that it can develop. Your lawyer's already indicated that she's seeking a continuance of this matter. The only thing I bring you out to tell you is you have the right to make offers, you have the right to solicit offers, you don't have to do any of those things, you have that right. If at any point in time when you are having some conferences with your lawyer and you feel that you need to share something with the court that you might need me to address for you, you should bring that to my attention. And if there are any other issues that arise that you think the court should or can or possibly address for you, you should not hesitate to ask me, and I'll do the best I possibly can to address those matters for you. And I'm going to reschedule it for a pretrial. And on this type of case, instead of 30, I tend to give at least 6 weeks for the pretrial date. So I'm looking to schedule it for the 18th of March. Is there a reason I should not set it for that day? All right, set a new pretrial 3/18. Is there anything, ma'am, that I can address that you need to bring to my attention? Don't talk about your facts or anything, but have been able to meet with your lawyer, you have a chance to talk with her, you know that you have the right to make offers. I'm not telling you have to do any of that, but you know that you have those rights.
Yes, sir.
Did you have any other questions for me?
No, sir.
All right, thank you. Thank you.
In October 2020, Stinson pleaded guilty to second-degree murder and making a false report to police. She was sentenced to 50 years in prison. The case exposed critical failures in Florida's child welfare system. Jordan had been previously placed in foster care due to safety concerns, but was returned to Stinson months before his death. In the aftermath, lawmakers introduced Jordan's Law, aiming to improve child protection protocols and better coordinate agencies involved in child safety. In May 2021, China Forney, an 18-year-old high school senior and promising athlete, was tragically shot and killed just weeks before her graduation. Jameer Manning and another individual, Alvin Foy, opened fire on a group on Essex Street in Albany. Forney, who was not the intended target, was struck and later died at Albany Medical Center. She had been planning to pursue a career in nursing, and her death left the community devastated. In October 2022, Manning pleaded guilty to second-degree murder and was sentenced to 20 years to life in prison. After sentencing, Forney's family expressed their deep sorrow, hoping Manning would carry the same pain they do each day.
You should think that all the days that you're in there, you should think about the things that you did and the pain that you caused us.
Every night when we go to sleep and we think about my niece, I hope he carried that same pain. Every single day of his 20 years to life, he should think about my niece.
In a separate trial, Alvin Foy was found guilty in April 2023 and sentenced to 25 years to life. The courtroom noted his lack of remorse, as he was removed for laughing during a victim's impact statement. On October 6, 2018, a devastating limousine crash in Schoharie, New York, took the lives of 20 people, becoming one of the deadliest transportation accidents in recent U.S. history. The vehicle, a 2001 Ford Excursion operated by Prestige Limousine, ran a stop sign and careened into a parking lot, striking another vehicle and 2 pedestrians. All 17 passengers, the driver, and both pedestrians were killed. Investigations later revealed the limo had faulty brakes, lacked proper certifications, and was being driven by someone without a valid commercial license. Nauman Hussein, the operator of Prestige Limousine, was found to have ignored repeated warnings about the vehicle's condition, leading to his arrest and charges of second-degree manslaughter and criminally negligent homicide. Initially offered a plea deal that included probation, Hussein later opted for trial.
We
gave him the best advice we could, and the client made the decision to withdraw the plea and go to trial.
In May 2023, he was convicted on all 20 counts and sentenced to 5 to 15 years in prison.
I will tell you this. I am not going to abide by the plea agreement.
First thing I thought of was, wow, this is a home run for the victims. This is something that they wanted. This is something that I think the new judge, Judge Lynch, understood. While it may affect the civil case, they want justice both criminally and civilly.
His legal team argued the trial had been unfair, but in November 2024, an appellate court upheld the conviction, stating the verdict was supported by the evidence and any procedural issues were not enough to overturn it. Hussein remains incarcerated at Attica Correctional Facility. The families of the victims continue to seek closure, believing justice was finally served after years of waiting. On May 24, 2021, Destiny Green was shot and killed during an attempted robbery on Wilbur Street in Albany, New York. She had accompanied others for what was believed to be a social media marketplace transaction when Brandon Rivera and Sincere Cancer opened fire on the vehicle she was in. Destiny, a student at Shaker High School, remembered for her warmth and ambition to become a nurse, was struck in the torso and later died at Albany Memorial Hospital. The community was devastated by the sudden loss of such a promising young life. Following a lengthy investigation, both suspects were charged. In November 2022, Rivera pleaded guilty to attempted second-degree murder and was sentenced in early 2023 to 25 years in prison, followed by 5 years of supervision. Cancer later accepted a similar plea in April 2025, avoiding a trial and receiving the same sentence. Though both men admitted to their roles in the shooting, neither was convicted of murder due to plea agreements, leaving Destiny's family with mixed emotions.
I'm glad it's over, that I don't have to come back and forth to court anymore, but I'm still sad because my child is not here. And that's never going to get better.
To honor her memory, the family created a scholarship fund offering 2 annual $500 awards to graduating students, an effort to keep Destiny's spirit alive through the futures of others. In April 2023, George Sapp provided 27-year-old Jacksonville singer Charity Huntley with half a Percocet pill during a night out. Later that evening, Sapp dropped Huntley off outside a hospital. Tragically, she later died from an overdose, with an autopsy confirming oxycodone toxicity as the cause. Although Sapp admitted to giving her the drug, he was not charged in connection with her death, but rather with the delivery of oxycodone, a second-degree felony.
You are going to today become a convicted felon.
Losing Charity is by far the hardest hit my family has ever endured. She was literally the light that kept us shining.
In May 2025, Sapp pleaded guilty. During sentencing, Huntley's family delivered emotional statements, expressing the pain and loss they continue to feel.
Losing Charity is by far the hardest hit my family has ever endured. She was literally the light that kept us shining. I pray that moving forward, no other family has to experience what I've had to experience.
While some spoke on Sapp's behalf, describing him as a caring person.
He means no harm to anybody. He's there to help people, to protect people. So yes, that's the person that he is, so.
The judge emphasized that her ruling was limited to the drug delivery charge and not to Charity's death.
You are going to today become a convicted felon. I am not sentencing him for retribution for Charity. You have to understand that.
Everyone knew who she was, so for that, we would just keep screaming her name.
He was sentenced in Duval County to 2 years of community control, followed by 3 years of probation and 100 hours of community service. Despite the outcome, Huntley's family remains committed to keeping her memory alive and raising awareness about the dangers of opioid misuse. In late October 2019, Alexis Crawford, a student at Clark Atlanta University, celebrated homecoming festivities with her roommate Jordan Jones and Jones's boyfriend Barron Brantley. On the night of October 26th, all three had been drinking heavily. According to later statements, Alexis became sick and went to lie down. At some point, Jordan found Brantley and Alexis together in the bathroom. Brantley denied wrongdoing, but Alexis later reported to a friend that she had been sexually assaulted. On October 27th, that friend contacted police, and Alexis underwent a rape examination, which revealed Brantley's DNA. In the early hours of October 31st, tensions between the roommates escalated. Jones admitted that she and Alexis got into a physical fight in their apartment. During the altercation, Brantley emerged and allegedly joined in. After Alexis died, the pair concealed the body and cleaned the crime scene. Initially, Jones misled Alexis's family about the results and denied knowing her whereabouts. But once Alexis was reported missing and her body was discovered, both suspects were arrested.
Knowing that information, did you confront Ms. Jones with that?
Yes, I asked her.
And can you tell the court what her response was when you talked to Ms. Jones about the alleged assault?
She stated the night of the 26th, they were at a homecoming Morehouse of Spelman, I believe, and they were drinking. Came home. She got a little sick. She went to the bedroom and woke up about an hour later and discovered Brantley and Crawford in the bathroom.
Okay.
And when she knocked on the bathroom door, Brantley came outside and said, "I didn't touch her. I didn't rape her."
Okay.
And then he continued.
Was that an unsolicited statement?
Yes.
He volunteered that?
Yes.
You can continue.
Then Brantley took her keys to her car, ran outside to where her car was parked, and argued with Jones for a little bit prior to driving her car away from the location.
Okay. And did Ms. Jones tell you that she did anything as a result of the defendant, Mr. Brantley, taking her vehicle?
She called 911.
And was her vehicle eventually returned to her?
Yes.
And during, I guess, the conversation with Ms. Jones and through your investigation about the sexual assault, were you able to determine if Ms. Crawford, she was awake or passed out during that?
The conversation with Ms. Jones? No.
Okay. And the conversations with other individuals from the hospital as well as other members of the Atlanta Police Department, what were you able to determine?
Ms. Crawford told them she was blacked out.
Now, as you're talking with Ms. Jones, does she begin to tell you where she, or if she knows where Ms. Crawford, or excuse me, yes, Ms. Crawford is?
During the conversation at headquarters?
Yes.
No.
Okay. What did she tell you about the whereabouts of Ms. Crawford?
Initially, she told me she didn't know where she was at.
And tell the court specifically what Ms. Jones said happened to Ms. Crawford on October 31st.
She stated while she was engaged in a fight with her, Mr. Brantley came out of the bedroom and killed her. And then killed her, put her in a plastic bin. They drove her somewhere and dropped her off.
And
Jones stated this about Barron Brantley?
Yes, sir.
And when you say plastic bin, is it the same plastic bin she had requested her friend purchase a few days later?
Yes.
Okay. After she provided you that information, can you tell the court what happened next?
We continued the conversation, and my main concern was to try to find Lex. So we got into a car, her along with her dad, and we drove to the area where she believed she was dumped at, and she was able to lead us to the area where she was dumped at.
Okay. And can you tell the court where was Miss Crawford's body found?
Exchange Park.
Okay. And where is it?
Decatur.
Okay. Now, after finding Miss Crawford, did you have an opportunity to speak to the defendant, Mr. Brantley?
Yes.
And when did that occur?
The same day. After we located Ms. Crawford, we had previously put a fugitive package together for Mr. Brown because he had a probation warrant, so we were still looking for him. The fugitive unit was able to apprehend him. I went to his location, I picked him up from where the fugitive unit arrested him, and talked to him from that location to headquarters.
And prior to speaking to him, did you read him the Miranda warnings?
Yes.
Okay. And after reading him those warnings, did he agree to speak to you?
Yes.
Okay. And was that interview audio recorded?
It was audio at the beginning, and then it was videoed when we got to the precinct, and audioed when we went downstairs for a cigarette.
Okay. Now, through your conversation with Mr. Brantley on November 8th, can you tell the court how that conversation kind of began?
And the initial conversation started, Mr. Brantley denied knowing where Alexis was at. And then I confronted him with some inconsistencies in his statement, and he admitted to being in the house. He admitted to Alexis, Miss Crawford. And while he was Miss Crawford, Jordan Jones put a plastic bag over her head.
Okay. And when you say in the house, are you talking about the 765 McDaniel Street apartment?
Yes.
Okay. And did he describe to you when Miss Crawford was placed in the Rubbermaid bin, the storage bin, if she was still alive?
He said she was dead.
And can you tell the court how he was able to describe to you that he knew that she was deceased?
She said she was breathing like she was struggling to breathe, and she had sounds of agony.
Okay. And did he describe to you that when they put her in the bin that she was no longer breathing?
Yes.
Okay. And that all occurred at the 765 McDaniel Street apartment?
Yes.
And that's here in Fulton County?
Yes.
Okay. Now, when Mr. Brantley was, I guess, describing to you what him and Miss Jones did to Miss Crawford, where was this occurring?
This occurred in the living room of 765 McDaniel Street.
Brantley eventually confessed to his role, and phone records and text messages later revealed the couple's attempts to cover up the crime. By 2025, prosecutors sought to admit their Instagram messages as evidence of a joint effort to mislead investigators, while the case continued moving through pretrial proceedings. In February 2022, Caleb Andrew Kennedy, a former American Idol contestant, was involved in a tragic incident in rural Spartanburg County, South Carolina. While driving a 2011 Ford F-150, Kennedy veered off course and traveled down a long, private gravel driveway, about 175 yards, before crashing into a detached garage. Inside was 54-year-old Larry Dwayne Paris, who was working when he was struck by the vehicle. He was critically injured and later died at the hospital. At the scene, Kennedy appeared disoriented and emotionally distraught, reportedly holding the victim in his arms. He told law enforcement he had taken a hit from a vape pen and had recently started a higher dose of Prozac, which may have caused him to become confused. Investigators found no immediate evidence of alcohol or drug paraphernalia at the crash site, but the prosecution pointed to Kennedy's own statements about feeling zoned out and experiencing an out-of-body sensation. A blood sample was taken for toxicology testing. During bond hearings, the defense argued that the crash was a tragic accident triggered by a medication-induced reaction.
Caleb is charged with felony DUI death. He is 17 years old. He's in the 11th grade. He is born and raised in Roebuck, South Carolina. He's got no record. By all accounts, from law enforcement I talked to and all other witnesses, no alcohol was involved. This happened around lunch, Your Honor. He was on his way to his girlfriend's house. He had recently been put on a prescription medication, which I can represent at the court. It was Prozac, and they had recently doubled his dosage, and he had some bad reaction, got lost on his way to his girlfriend's house, and randomly wrecked it down this dirt road in somebody's garage. And unfortunately, Mr. Paris was in the garage. And when law enforcement got there, Caleb, a 17-year-old, was holding Mr. Paris in his arms and crying. It's a very sad situation and accident. Caleb has no record. He's not a flight risk, not a danger to the community. There's no evidence besides what law enforcement and the state is claiming. Caleb said that he took a hit off a vape pen at some point, but we don't have any blood saying there was, or anything at the scene saying there was drugs or alcohol involved, only these alleged statements by Caleb. And yet, the law enforcement is also saying that Caleb was very disoriented and didn't know what he was doing or saying at the scene. So it's a very confusing situation. We're still trying to figure it out. Apparently he had met some individual to get some cigarettes. The guy had bought him some cigarettes at this a location of this Japan house. But there's no surveillance showing that Caleb was there. And in fact, the witness claims that he did not give Caleb any kind of vape pen. So, Your Honor, we think a reasonable bond of $20,000 with GPS house arrest is appropriate. Honestly, this is probably a reckless homicide case. It's not a felony DUI death. But that's all as far as bond, Your Honor. To get bonds, we're talking about he just turned 17, Judge, and there's no evidence at the scene of any alcohol or anything else, and no marijuana, nothing, just cigarettes. I just don't. Your Judge, it's unfair to this kid to be sitting in jail for months on a backlog with SLED, and the fact that a magistrate down in the jail didn't do his job anyway and set a bond. I'm just sorry, Judge. I'm standing up saying a bond should be set today. It's ridiculous. Just because they don't have their act together should not penalize us.
They emphasized Kennedy's lack of a criminal record, his age, and the absence of proof that he was under the influence of illegal substances. In contrast, the prosecution painted a more serious picture, emphasizing the recklessness of Kennedy's actions and presenting visual evidence of the long driveway and the location where Mr. Paris was struck.
Your Honor, this is a dirt, and I could go show you the video. This is out in basically 2 houses down this road. He traveled all the way down this gravel road, which is basically a 1-lane road, Your Honor. You'll see the next one here. This is actually the turn where you go here and it turns. And if you go out in that area, Your Honor, there was nothing disturbed here, nothing where he fishtailed or anything like that. And Your Honor, can you see this is 175 yards from the road all the way to and you see the building I think I'm pointing at. That's the building where this ended. Mr. Paris, Larry Paris, was right there at that location there, Your Honor, from there. And he was on the phone with his best friend talking to him, and suddenly the phone goes dead when he gets hit. And the best friend actually calls his wife and says, something just happened. I don't know, you need to check on him. And he was actually on this pad right here in this area when he got hit. And he literally, Mr. Kennedy drove, and it would have kept on going. There's a huge piece of machinery back here that weighs a lot that's used to cut metal. And he worked with boats, a lot of metal and things like that. You can see the speed and the damage there. The problem is it looks like he sped up once he got to the driveway, because he couldn't have made that curve at a very fast speed from that standpoint. In this case, Your Honor, from that standpoint. And let's see, I have one here. And Your Honor, Mr. Paris, this is a picture of him and his family from that standpoint. And he lived there. And then just briefly give the facts, it's happened on February 8th. Mr. Kennedy was driving a 2011 Ford F-150. You saw the truck there, Your Honor. Went all the way to the private driveway. And like I said, this is in a very rural area, Spartanburg County, near the Packlet area, towards that direction. It appears that he was at the Walmart and met with a friend there, got a hit from his way, told law enforcement, drove down the road at 295, apparently got lost. and went to this address at 270 West Murph Road, Your Honor. And like I said, it's 175 yards. Larry Parris is the owner of it. He's outside his utility building, Your Honor, got hit. When officers got there, Your Honor, he appeared to be very lethargic, disoriented. He basically told him that he'd been at Japan House, met with that friend there, thought he took a hit off marijuana, Your Honor. Felt like he was zoned out and everything from that standpoint. They definitely felt he was under the influence of thing. He had actually told a witness at the scene that he had basically f***ed up, but he was f***ed up from that standpoint, that he was tripping at the time. The problem we got, Your Honor, from this standpoint, this is the danger. If he's taking Prozac on top of that, I don't know what medication. That's one reason for the medical records from that standpoint, to find out what he told the hospital from that standpoint. But if you watch the videos and everything, I have Corporal Batson here also going to testify concerning medical records. He's definitely under the influence of something. I don't know if it's a combination of what he was on with what he took, but there's no question if you see these videos from that standpoint. And he admits it. He basically said he had out-body experience and when this happened from that standpoint. So we feel like he's a danger to the community. Obviously want to take court take consideration from that standpoint.
Family members, including Parris's daughter, gave heartbreaking statements in court, vividly describing the moment they found him, the emotional toll of his death, and their desire for justice.
My name is Chelsea Harvell, and I'm Larry's daughter. For 2 weeks now, I've laid down at night and closed my eyes, only to see and hear the same things over and over again. My daddy laying in his own shop, moaning, groaning, and hollering with a stranger that wasn't calling 911 or even calling for help, just sitting there with a blank look on his face. Thank goodness me and my mama were home. I see my daddy's hazel eyes and wrinkles on his face. I hear my screams begging for him to look at me and stay awake. I hear the firefighters cutting the door to get in there to him. I hear the surgeon telling us he's not going to survive. I see the footprints coming from the room he was in at the hospital. I hear my mama begging and pleading with God to save him. I see my daddy laying there in a hospital bed, dead, with tubes coming out of his mouth. I see his 73-year-old father sitting beside him, holding his hand and sobbing. I see my mama kissing her husband of 35 years on the forehead for the very last time. So if I have to relive that every day for the rest of my life, please explain to me how he even has the opportunity to see the light of day ever again. And please explain to me how someone with a conscience could ever defend him. I'm 25 years old and have to live without my daddy for the rest of my life. This should not even be an option. Nothing has changed between February 8th and today, so why are we even here? Why am I having to vouch for my daddy? There's no question what he did. He killed my dad, point blank, period. And now there's a chance that he gets to go home to his family? That's absolutely infuriating. I sure do wish I could pay a little bit of money, or a lot of money for that matter, to have my daddy back, but I can't. That's not possible because of something he did. Not me, not my mom, not my husband, and surely not my dad. Him. He did this. He should have to sit there. We request that bond be denied.
Initially held without bond, Kennedy was eventually granted release in May 2022 under strict conditions, including a $50,000 bond, house arrest, and mental health monitoring. More than 2 years later, in November 2024, Kennedy pleaded guilty to felony DUI resulting in death.
Okay. Yeah, I can tell you about it, Judge. Sorry, usually the state goes first. Sorry. This is another case where the magistrate down at the jail deferred to the circuit court. Caleb is charged with felony DUI death. He is 17 years old. He's in the 11th grade.
Toxicology reports confirm the presence of both Prozac and THC in his system at the time of the crash. At sentencing, Kennedy was originally given 25 years in prison and a $25,000 fine. However, that was reduced to 8 years in prison, 3 years on house arrest, and 5 years probation. He was also ordered to attend substance abuse and mental health treatment and received credit for time already served. In June 2014, Charlie Bothuel V was reported missing from his home in Detroit by his father, Charlie Bothuel IV, and stepmother, Monique Dillard Bothuel. The disappearance sparked widespread concern, drawing attention from local authorities, the FBI, and even national news outlets. For nearly 2 weeks, investigators searched the neighborhood and surrounding areas, including the family's home, multiple times. Yet on June 25th, in a stunning development, Charlie was discovered alive in the family's basement, concealed behind a barrier of boxes. He appeared thin and disoriented, but physically safe. Authorities launched an investigation into how the boy ended up there, suspecting that the situation was more than a mere case of a missing boy. The focus quickly turned to the parents. In April 2015, prosecutors filed charges against the couple, including torture and second-degree child abuse. The prosecution alleged that Charlie had been subjected to excessive discipline, forced to follow a strict exercise routine, and denied basic needs like food and water. In June 2015, during an 8-day preliminary hearing, the judge reviewed testimony from several witnesses, including a pediatrician who had never personally examined Charlie.
With respect to, I want to start with the testimony of Dr. Nazar, and I did allow the people to amend their complaint. The doctor testified on direct examination as well as cross-examination that she made her determination that the child had been tortured, and she used the word tortured, even though it's not a legal term. She said that it was based on her review of the medical history of the child, which has been determined by this court to be incomplete. She said she made her determination based on the medical records of the child, which has been determined by this court that those records were incomplete. She also indicated that she made her determination based on interviews, and the interviews were Kids Talk, FBI, different interviews, and just on some of the cross-examination of Charlie himself, this court finds that those interviews were inconsistent. The doctor also testified that she made her recommendation based on photos of the child. The doctor indicated that in order to determine whether or not a child is abused or tortured, as she indicated, she looked at the fact that Charlie had been isolated. She specifically stated that Charlie had no friends, no girlfriend, and that he was homeschooled. However, the testimony on the record by Charlie himself indicates the total opposite. Charlie testified that he did spend weekends with his mother, that he did have the opportunity to hang out with his cousins, that he did go to the park on occasions, that he did leave the state and spend time with his grandfather in another state. He testified in one of his interviews that he had, anytime he went away from the house on Nicolette, that it was never unmonitored by the defendants. Well, Charlie's testimony on the stand contradicted that interview, because he did go to his mother and to his cousins and to other places, and he was not always accompanied by the defendants. During the examination, the doctor said she made her decision based on the fact that he was isolated from what children do. However, it was clearly brought out on the record, as far as this court is concerned, that Charlie had access to social media. Now, he denied ever using it, and then he said, well, he did, but the specific posts that he was cross-examined on, he said he did not post those things, but he never denied having the social media accounts, which goes against the conclusion of the doctor that Charlie was isolated. The doctor also indicated that Charlie was homeschooled, which happened to be a part of why she ruled that, or she thought that he had been isolated. And it's clear from the record, from Charlie himself, that he was homeschooled. He was having problems in school. He was not making the grade. He was having behavioral issues. And so the decision was made to homeschool. And unless the people are going to find that the state somehow failed, who's responsible for monitoring homeschool, and I didn't see the state, anybody from the state indicated as a defendant in this matter, I certainly can't conclude that the fact that the child was homeschooled is a part of isolation for some cruel or some kind of cruel intention to torture this child. The doctor went on to state that she made her ruling or her determination based on the fact that Charlie had been deprived of water and food. However, during his testimony, Charlie indicated at first, he said that defendant Monique Bothuel, brought him food in the basement. He later testified that he would actually sneak upstairs and get food, And then in his FBI interview, he said that Monique Bothwell never brought him any food. He totally did not tell the truth. It's more than just a child being confused and being afraid. They are totally inconsistent stories. What was even more glaring with respect to the testimony about the deprivation of food and water is that on June 25th, 2014, and I'm on page 16 of 79 of the doctor's report, where the hospital said at the time of admission, and I quote, well nourished. No one made a finding that this child had been deprived of any water or any food. It says it. Nobody brought it out. But I told you all, I read all of the records, all of the hundreds of pieces of paper that you all decided to admit into testimony. And glaring in the records, page 16 of 79, it says, child well nourished. The doctor also indicated that she made her recommendation based on the fact that Charlie had been deprived of some of the basic needs, such as using the bathroom, and he was made to hold his bowels. At the hospital, Charlie stated on more than one occasion that he had not had a bowel movement for 10 days. While this may not be important to anyone else, it was important to this court because Mr. Bothwell, Charlie Bothwell, the complaining witness, got on this stand and testified that he would sneak upstairs and use the bathroom. Again, this is more than just a child forgetting something, being nervous, totally inconsistent stories, and I could not believe what he said. The doctor also testified that she made her recommendation of torture because of the excessive exercise and weight loss. However, on cross-examination, Dr. Nazar, who never had a conversation with Charlie, who never examined Charlie, who did not have the complete medical history, did not have the complete medical records, knew about the inconsistent statements in his interviews, assuming that she did. I could never really get clear on whether or not she reviewed all of the interviews, but she never talked to Charlie. And on cross-examination, she indicated that it could have been that he did not have enough food, or it could have been that it was too much exercise that could account for the 25-pound weight loss that the child has sustained over a 2-year period. Now, I bring that point up because when the doctor says, well, it could have been the lack of food, again, the hospital who examined the child at the time that he was brought in, the records say, well nourished. In addition, Dr. Nazar, on cross-examination, admitted that she never reviewed the records of Dr. Mosby, who had examined this child with respect to his weight issues and had developed a plan for Charlie with respect to his weight loss. Those things are important if you're going to make a determination that a child has been tortured and that part of your decision is based on the lack of food or excessive exercise. So now it takes us to the basement. In order for me to find that the defendants tortured this child, I must find that there was a forcible restriction of his movements or forcible confinement of where he could not move about, or they were interfering with his ability to move about. The court cannot find that, and here's why. First of all, I heard officer after officer get on this stand and testify that they searched the house. There was a missing child that had been reported, and they searched the house. Not only did they search the house, specifically, they searched the basement. Not only did they specifically search the basement, but they did it on more than one occasion. There were officers that testified that there were dogs that were brought out to this scene, dogs who never detected Charlie. Now, it's very important to understand that the cadaver dog did pick up a scent of Charlie in the back of the car that was driven by Mr. Bothwell and in a dumpster, and I believe there was another hit. However, there was some testimony given that the cadaver dog wouldn't pick up his scent if he was alive. It's for decomposition of the body. But Charlie is still alive. He really did show up and testify here at the preliminary examination. And so in order for the court to find that this child was forcibly confined to a basement, not given food, but then given food, that he was forcibly confined to a basement, that he heard his father looking for him, saw his father looking for him, He testified that his father didn't put him in the basement, yet he never yelled out, yet he never stood up, yet he never made himself known. I just don't believe him. I don't believe that he was in that basement, and as a part of the preliminary examination, I am required to assess credibility. It doesn't get to the finder of fact if I find the witness to be wholly incredible, which is what I found this witness to be with respect to his confinement in that basement. I don't believe that he was there 10 days. I don't believe that they restricted his movement. I don't believe that the police were there and they did this thorough investigation. The FBI, the evidence recovery team, the trace team, the dogs, and nobody found little Charlie in the basement of his home. I just cannot believe it.
The doctor concluded that he had been tortured, citing weight loss, isolation, and lack of nourishment. However, the court found much of this evidence unreliable or inconsistent. Charlie's own statements during interviews and court testimony often contradicted each other. He initially claimed to have been deprived of food, but later admitted to sneaking upstairs to get meals. He also described being kept in the basement, yet acknowledged visits with his mother and cousins and using social media, suggesting he was not entirely isolated. When it came to the central claim that Charlie had been forcibly confined in the basement, the court was not convinced.
I am finding that the people have not met their burden with respect to count 1. I am dismissing count 1 as to torture. With respect to count 2, child abuse in the second degree. You're right, Mr. Smith. I must find that they used reasonable force. The testimony on this record was that this child was punched and that he was choked, that he was disciplined with a PVC plastic pipe. Also, the pictures were consistent with his testimony where he said his father took that pipe, put it in his chest, and broke the skin. I reviewed a photograph that was consistent. The doctor testified that that scar was consistent with the use of that PVC pipe. Also on his buttocks, I reviewed that picture as well, where the child testified that he was in fact hit with that PVC pipe on his rear end, and I looked at the photos and it appeared that that testimony was consistent with what was shown in the photos, and that is not reasonable force. It is not reasonable to discipline a child in that manner. And so I am going to find that the people have met their burden with respect to count 2, child abuse in the second degree, as to both of the defendants. That is the court's holding. Anything else on behalf of the people?
Despite multiple police searches, including the use of trained dogs, no one found him during the 11 days. The judge noted that it was implausible for such extensive efforts to miss a boy hiding in a small area. She ultimately dismissed the torture charge, stating the evidence did not meet the legal standard. However, the judge did find grounds for the child abuse charge. Charlie testified that his father disciplined him by physically assaulting him, describing specific injuries that matched photographs submitted as evidence.
Ever go anywhere with friends?
No.
Why not?
That didn't happen.
Why not?
I never went outside unless I was allowed. I was told to basically lay across the table, the dining room table, and I basically got spanked on the butt.
With what? Anything?
A wooden stick for a short while, and then a plastic PVC pipe.
All at the same time?
Yes.
What did she do?
Sometimes she would push me, or I got choked once.
By her or someone else?
Her.
Can you tell us where you had injuries?
On my butt.
Well, how do you know it was injured? What happened?
Because the skin was split open.
Well, how do you know that?
I could feel it, and I saw it before.
Okay. What would happen when the skin would be broken, if you can tell us?
It would bleed.
These acts, the court ruled, went beyond reasonable discipline and justified the continuation of the abuse case.
I turned it down because I'm not guilty. I worked my whole life taking care of vulnerable populations. I used to be a foster parent to 3, a father of 4, grandfather to 2. I've taken care of hundreds, literally, if not thousands of patients. I've never been accused of, even suspected of, hurting anyone or doing anything wrong. And to, say that, I'm a child abuser just so I avoid jail, I can't do it.
The other end of it is up to 10 years.
I know.
So you just move forward. You're willing to roll the dice.
You know, yeah. You know, it's a very real concern, you know, and everyone has, you know, told me that, especially with all of the negative publicity and with a lot of the horrible things that, you know, people come to believe about me. But you know, I never committed a crime in my life. I spent my whole life, and with the whole world is like seeing this, and like literally, if I had done any, you know, abuse or any wrong thing to any single person, somebody would have said something. You notice, not one single person, nothing, nobody, not before, not now, has come to say, oh yeah, he did this, because it's not true. That's not who I am. I was a foster parent when I met my wife. Before we had our own kids, I had 3, you know, foster children. So it wasn't my first time dealing with the state of Michigan as far as being a foster parent either, never a complaint. And, you know, we did everything that we could to help my son into this. This is just, I mean, it's a tragedy. So.
Are you all alone now? Does Monique have the other children?
Monique, since Monique, after Monique took the plea deal, they gave her the kids back. So basically, admit and say that, you know, you're, you know, admit to a criminal crime against the, you know, kids, and we'll give you your kids back. Before that, I mean, it's just, the level of coercion. You know, my son Luke, you know, he's autistic, didn't get the services that he needed, and he regressed while he was in foster care. It was time for them to be home. Yeah, I get to see him every weekend.
You guys are separated or going through?
We're separated. Yeah, we're separated.
You hope to get back, or it's just the strain was just impossible to survive? That's a lot of stress.
I know. You know, I hate that my family was broken, you know, by this. I never thought I'd be 47 years old and without my family and actually looking to go into jail, potentially. That's just, you know, I should have worked hard, went to school, just, you know what I'm saying, my whole life, did everything I could to, you know, avoid, you know, something like this. So it's, I mean, in one sense, it's surreal, but, you know, I've been, you know, facing it, you know, for so long now. I mean, the reality is there. I just, I don't know, I want to fight for justice. I'm hopeful.
To see young Charlie?
No, I haven't been able to see my son Charlie since, you know, since they took him from me.
And you want to tell him?
In January 2016, Charlie Bothwell IV accepted a plea deal, admitting guilt to a misdemeanor charge of 4th-degree child abuse. He received 18 months of probation, was ordered to attend anger management classes, and lost custody of Charlie. Monique Dillard Bothwell reached a similar agreement. Her charge would be dismissed if she avoided further legal trouble for 6 months. As of the latest public records and media coverage, no additional legal action has been taken, and both parents have complied with their court-ordered conditions. Charlie, who remained largely out of the public eye following the case, is believed to be continuing his life away from the spotlight. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.